Before it's ready for oral argument and an ultimate decision by the justices. Other staff here at the court include 11 law clerks. So each justice has 2. The Chief Justice has a 3rd. We have a team of 3 staff attorneys who work on a lot of the cases as well. We have security officers, obviously. The courtroom monitor is the person who sits there and makes sure that the record of the oral argument is properly kept and maintained. And then we do have interns who frequently come here during either as experts, more about the justice system in general and the Supreme Court in particular. I'm a lawyer by training. I went to law school, worked for a couple of years, came here as a law clerk actually in the mid-1990s, then practiced law in Concord for about 15 years, returned here as the deputy clerk within the clerk's office, and then I've been clerk for the last 3 years. I had the misfortune of becoming the clerk 2 months before COVID hit, which presented all kinds of challenges that I know you're aware of, but the court never shut down. We went to remote operations, so the type of argument that you all just saw and you're about to see, we did via WebEx, which is like Zoom, and that continued for about a little under a year, and we went back to in-person arguments in 2021. The court has about, I'd say about 125 to 150 oral arguments per year. Not every case that gets filed here gets an oral argument. There is a sort of a screening or filtering function to determine whether oral argument would actually help decide the case. The way the court does it is essentially 9 months of the year are argument months, so the summers tend not to be, and December is a lighter load, and in those months the court tries to focus most of its attention on preparing and really finishing the opinions that can sometimes, the opinion drafting process can accumulate from all of the oral arguments. So about 9 months of the year, 3 days of those 9 months, so about 27 oral argument days per year, and the court typically hears anywhere from 4 to 6 per day, I'd say. So that's how it adds up. The next case, which I won't go into in any detail, is probably more on the law side than the fact side, because as you all received the briefs, the case was decided at what's called the motion to dismiss stage. And Attorney Lehman, please correct me if I say anything totally improper. No, so it was dismissed at the motion to dismiss stage. So if there was a complaint filed, that's the way to start a civil action in New Hampshire courts, also in federal court. And the complaint is typically the plaintiff, the one who initiates the action, makes a series of factual allegations and requests legal relief as a result of that. And the other side can file what's called a motion to dismiss that essentially says, even if all those facts are correct, even if all those facts and allegations are correct, you're not entitled to legal relief. And that's how the case got here. The trial court agreed with the school district that there was no basis for legal relief. The plaintiff appealed, as I was describing to you. It's what's called a mandatory appeal, so that this court had no authority to not take it. Once it was accepted, it worked its way through the briefing process, and you got to see those products.
That's this.
Yes. After it was fully briefed, it was reviewed by staff and the justices, and decided that it was an appropriate case to have argued. And it was probably scheduled. I don't have the case record in front of me. Probably within 3 months of when it was fully briefed.
It was scheduled before it was fully briefed.
Okay, all right. So, meaning the reply brief.
The reply brief came out.
Yeah. So, once each side gets a brief in, so the plaintiff appellant filed the first brief, then roughly anywhere from 30 to 45 days later, the other side filed a responsive brief. That's when we consider it sort of ready for the next step. And in this particular case, it was decided that it was an appropriate case for oral argument. The appellant gets the final word both in briefing and in oral argument, has the opportunity to file what's called a reply brief. So there can be 3 briefs. And this particular case was actually scheduled for oral argument before that reply brief came in. So enough from me. This is Justice Hans Marconi.
And I'm in here because I'm disqualified from hearing this case. So I just thought I'd pop in and say hi and borrow your teacher for just a moment, because I have something I want to talk to her about, and answer any questions that you might have. Not on the last case. Can't tell you how we're going to decide that one. Yes?
No, I have a question. I'm just confused why you disqualified from this case.
I can't tell you. There are certain bases for disqualification, and so we have to review cases, and if there is a basis for disqualification, then we take ourselves off the case. So we will be hearing, and the case will be in the good hands of my colleagues. Yes?
Just one more question.
Sorry. What I was saying, how long did the judge normally deliberate before they give like the verdict on the case?
We have a process. Everything's a process.
Got it.
So after we hear the argument, we sort of take our temperature, because we don't talk a lot beforehand. So we sometimes do, but mostly we're reading the briefs and doing our own research, and then once we hear the argument, hear from counsel, we sort of meet and take our temperature. And the case is assigned to a specific judge randomly. Before we even start the process, we pull names of cases out of a silver pitcher. It's a very high-tech thing. And so we know going in who's writing. And once we get everybody's input back, chambers with our law clerks, we go off and try and write to the sense of the court. And as we dig in deeper, sometimes we can do that, and sometimes things come up that change our mind. That process takes months, and then we have a system of review, and then we finally publish it. So it takes a while. Yes?
Would you say that you and Justice Hassett did ask most of the questions, or was that just happens in case on the previous law?
It depends on the case. So sometimes I'm fairly quiet, not always. And sometimes he is, and it really depends on the case and the subject matter. And whether, and sometimes someone else will ask a question that I was thinking of asking, so I don't. Is that it? Okay, all right. Anything else? Any other ones?
Going back to the question about refusal.
Yes.
At what standard do you hold yourself to refusal, and can you discuss that with other justices? And Supreme Court ought to recuse itself from the case?
We have a code of conduct which talks about conflicts that arise, so we follow that. Sometimes we confer with our colleagues, sometimes we confer with him, rather than on his head. We like to pull ourselves off cases at the earliest opportunity. We have a list, sort of in the back, so that certain lawyers, issues, law firms, companies that I might have represented in the past, all those things, we have a list, so we try and catch it at the earliest opportunity. Sometimes you get into a case and you find out because of who participated, not necessarily the named people, but who participated as a witness or something, and so you may not find out till you're reading the briefs. So we try and do it at the earliest possible point. Good question.
Yeah, so I'll piggyback on that.
Yes.
There are really two things. One is, as Justice Marconi mentioned, there is a code of judicial conduct which has a particular provision governing recusal / disqualification. And it sets forth sort of specific grounds that require disqualification. One of which might be you have a financial interest in the outcome of the case, or your spouse who lives in the same household is a party to the case, or is the attorney arguing the case. There's also kind of a catch-all that says, or at any time, your partiality might reasonably be questioned by an objective observer. So that's sort of the general catch-all. That's sort of the legal standard. Then the procedural standard here is the justices do sort of independently assess that. But if somebody on the case, a party to the case, thinks that one of the justices should be recused, there's a procedural rule requiring them to file that motion as early as possible in the case, rather than wait to see how things shake out, and then say, oh, if I had known she was going to rule that way, I would have sought her recusal. The thing that's different, I think, here versus the U.S. Supreme Court is that if there is a motion for a justice's recusal, that justice has the authority to decide that himself or herself in the first instance. But if a party is displeased with that ruling, the party can file a motion for reconsideration that then goes to the full court. At the U.S. Supreme Court, each justice decides for himself or herself with finality. Meaning, if Justice Scalia decides that the hunting trip with the vice president is not disqualifying, his colleagues just have to take that at face value. That's not the case here.
Personally, do you think that the U.S. Supreme Court should be held to the same legal standard that you're held to? I know you mentioned, like, spouse being a party to the case or having financial interest. Like, do you think that they ought to have recused themselves from cases such as this?
It's an interesting question because part of avoiding the appearance of bias or partiality, at the same time we have an obligation to sit on cases. So at times you have to weigh whether in your mind you really, whether it looks bad or whether you really can't decide the issue. I think that's what, I don't know, I haven't been there. I think though that's what the U.S. Supreme Court does, is they make that determination whether they can be fair, and I would trust that, because I know when I have to make that decision, I've got those two competing interests in mind, which is I've got to sit on cases. When I don't, it leaves only 4. And then if someone else just drops out, then it leaves only 3, and so I have an obligation to sit on as many cases as I can. So don't know what they're thinking, but our process seems to work.
And in New Hampshire, the legislature has also weighed in and identified some particular grounds in which a justice cannot sit on a case. And the two main ones are the judge or the justice was the trial court judge in that case, which can happen when judges get elevated. I mean, that's kind of a no-brainer. And obviously, sometimes our justices come from the ranks of practicing attorneys. So a justice cannot sit on a case in which he or she was a lawyer in the case below.
And if you come from a firm, even a case where that case was active, when you were at the firm, because there's an assumption that everybody's aware of everything that's going on. And our law clerks, this is not statutory, but we avoid appearing when our law clerks, after they get done being law clerks and become lawyers, and they come in here, if it's within that first year, then we can try to avoid sitting on that case. All right? Good.
Clerk TV.